Thank you for joining us for 3Bs on the Law podcast, hosted by Trisha Barita, Camille Canali, and Susan Dawson. Disclaimer, this podcast is for entertainment and informational purposes only, not meant to provide legal advice, and does not create an attorney-client relationship. Also remember, laws change or they differ by jurisdiction, so this is not a substitute for seeking legal counsel in your jurisdiction on the current law applicable to you.
Hello, and welcome back to 3Bs on the Law. With COVID cases on the rise, we thought it would be a good opportunity to revisit the Family First Coronavirus Act that we were talking about so much over the summer and last spring. That would include your Paid Sick Leave Act and the expanded FMLA portion of the FFCRA. So, Trisha, what are you hearing out there? What are you seeing? Are you seeing people asking questions related to the FFCRA?
Yeah, I think people are trying to remember if they haven't had a COVID case in their workplace in a while, reaching back, going, okay, what is it that exactly was I supposed to do? How does this work again? Do I need to, make sure that this person gets FFCRA leave, or do I give them FMLA first, or do regular FMLA first, or do I give them vacation or sick or PTO? And so, that can be, if you don't remember all the millions of questions and everyone's kind of all in tune to that, a lot's happened since the DOL released all those FAQs and we got through the regs. So the answer to that, if you're trying to figure that out, should be that, you're looking to give them their FFCRA leave first, because that's the way it was written, right? It was written in mind with that you're not going to suck up the vacation of the employees. You're going to give them this opportunity to take this leave. I think when it was created was that generally these people are taking it because they're sick with COVID, right?
Or that they're quarantined. I mean, the whole point of the act was to also compensate, even if you're not sick, but you can't go into the office because you have to be quarantined at home, either because you're asymptomatic or you had contact.
Right. So then when you're looking at how you deal with that, what if they used all that up by now? Right. And now you're revisiting it, you're getting more COVID back in the workplace. How do you handle it if they've already used up their 80 hours? What's left for them? Of course, they have the expanded FMLA, but that's related only to the care provider or a child, right? And you needing to care for a child. So how do they deal with that? Then you can go into your other forms of leave that are available for you. So that may be, PTO if you have that in your handbook, or vacation or sick, or possibly ADA leave if needed, that's unpaid leave, or FMLA, regular FMLA, right, guys?
Right. And I think with schools shutting down, we're seeing more and more parents, due to the rise. Some schools here that were allowed to open up now have to shut down and kids are at home. And so we're seeing that more of that, parents needing to stay home to care and, quite frankly, supervise homeschooling, because young kids, can't focus on Zoom for more than, half an hour at a time usually. So, the parent actually has to sit with the child, and that's taking into work time too. And so we're seeing a rise in that reason for taking the expanded leave.
Yeah. What are you seeing, Susan?
Well, I'm seeing that a lot of businesses have just kind of lost that rhythm of dealing with the COVID cases. Back in May and June, when we were, really rolling with this stuff, people had become aware of what the laws were. They were following the processes. If someone calls in, they send the standard form, they have the employee fill it out. But then cases kind of started to decline. The world started opening up again. Companies started getting a little bit more complacent in their following of the procedures. And now here we are, and they're getting inundated with calls. It's not that little trickle that it was, or maybe everyone was healthy for a while, but suddenly they're dealing with more and more calls, and they're forgetting to go through those steps. So I think it's a good idea for us to kind of walk through those just high level basic steps when it comes to this law as a refresher course, because, people throw out the leave, right? So Family First Coronavirus Act, we're talking about two separate acts. There's paid sick leave, and then there's expanded FMLA. And I have a lot of clients getting confused again on what those two things are. So what do you want to, who wants to just take us through a quick refresher? Trisha, you want to, or
Yeah,
I mean, a quick refresher?
So maybe we should do the first 3 reasons and the payment required, and then the last 3 reasons and the payment required. I always think that's a great way to break it up.
I was just going to clarify that for anyone that's kind of confused and squishing these together. They're actually, if you read the actual act, they're in 2 different even parts of the act. They are actually separated out as 2 different types of leave. One of them is falling under like the FLSA and Fair Labor Standards Act, which is your overtime and your, minimum wage kind of laws, versus the FMLA, which is an already existing Family Medical Leave Act, of course, with its many reasons that applies to most, employers that are over 50 employees. So they're totally 2 different ones. They get squished together because, of course, what did the DOL do? They put them together on that poster, which I think can get a little confusing because of the way they interact with each other. So Camille, if you want to break down those different 6 reasons, I think that will help out.
So the Family First Coronavirus Response Act, FFCRA, that we've been talking about, applies to employers with less than 500 employees. And of course, if you're lucky enough to live in California, California has supplemented that. And now employers with over 500 employees also have to comply with the same requirements generally. So make sure you check that out. But essentially, for any of these 3 reasons, you have to pay a maximum payment of $511 per day, or $5,110 in the aggregate. If their full salary is more than that, you're off the hook for the balance. But if you are an employee is subject to a federal, state, or local quarantine or isolation order, and I know there's been some confusion about that, about what an order is versus a recommendation. And I think some employers have gotten hung up on that. If the employee has been advised by a healthcare provider to self-quarantine due to concerns related to COVID-19, and I know there were issues about whether they had to provide a doctor's note, and what was the answer? I know, Susan, that was...
You cannot require a doctor's note.
You got it. And the last one is the employee is experiencing symptoms of COVID-19 and actively seeking a diagnosis. So for those, you have to pay full salary. And Trisha, do you want to handle the 2/3 salary reasons for the 80 hours?
Sure. So at the 2/3, the qualifying reasons are going to be what they call number 4 and number 5 and number 6. And so we'll talk about number 5 kind of on its own, I think, because that's a little bit more complicated. But number 4 is caring for an individual subject to an order described in number 1, which is the subject to federal, state, or local quarantine that Camille was talking about. Or as described in number 2, which is the healthcare provider advising that you should have some self-quarantine related to COVID-19. The number 6 reason on the list for the DOL poster is experiencing any other substantially similar conditions specified by the U.S. Department of Health and Human Services, blah, blah, blah. Nothing's been declared, so don't worry about that right now. We'll stay tuned. I think we all think that they had that put in there as a catch-all, because at the time that this was all created, they didn't really know, would there be multiple different coronaviruses? Would we be, everyone's like, oh my God, God forbid, no more. But COVID-20, COVID-21. So we haven't heard any of that. And they were trying to figure out a way to reach back to this and pull it back in and continue to have this paid sick leave available to employees. So then the number 5, I don't know if Susan, you kind of want to explain that, but that's the tricky one that gets you into the EFMLA, and you're using the paid sick leave together. Well,
the number 5 is really due to a child's school or daycare is closed, and there's a lot of details that we probably don't need to go into in this episode. We did go into those in detail when we talked about schools back in session. We had a podcast where we talked about what does that mean and what's closed and when does it qualify. But for number 5 is really childcare. So what I try to explain to businesses when I'm talking to them is really focusing on those first 2 categories. They're subject to a quarantine order, which means they either have COVID or they had contact with COVID, or they might have COVID and someone said, stay home. right? I mean, by healthcare provider, right? Or category 3 really only deals with going to get tested, going to the doctor, that wait time, that day, that one's such a short period of time. And that's what trips a lot of people up, because they're like, well, they went to get tested. Do I have to pay them while they waited in line to get tested? If they were supposed to be working, why, yes, you do, right? That's category 3. But then after they were tested and they were told to go stay home until they got the test results, now that's category 2. So these categories get confusing to employers. The bottom line is, if they're being tested or a healthcare provider is telling them to stay home, they could qualify for FFCRA. So send them the form, right? All businesses should have a form for requesting this leave. Send them the form. Let them fill it out. Make sure you have that in place.
Or if they can't fill it out, you can maybe orally fill it out with them on the phone until you can get, because let's face it, you're not bringing them in to fill out the form. And, I've run into problems with employers where they're dealing with employees that don't have computers at home. They don't have maybe high level phones. So the ability for them to sign and fill out these forms may not be there. But, going to the extent where you're getting the information that's needed on these forms, both for try to get the tax benefit of this and also to comply with the FFCRA and be able to show you complied. I think you're right, Susan. I think we've heard it loosely termed this sort of breakdown of this self-care kind of, if you're in the first 3 reasons, you're talking about the individual actual employee. And then when you kind of get into 4, it's they're caring for an individual or they're caring for a child, and leaving 6 out of it because that's the unknown. But if you break those down, that's the first 3 you're looking at where you're paying more up to the $511 a day full-time and pay, and then the 2/3 pay. But I mean, after you start to get into all this minutia and you're breaking it all down, don't forget there is a difference. Don't just start paying people full pay and you don't know, because you're not going to get the tax credit back for that once those reasons are explained to the IRS. So you need to make sure you really understand this and that you're following it appropriately. And let's talk about the elephant in the room here, right? Like December 31st, 2020, this is supposed to expire, supposedly, right, guys?
Well, it does. I mean, it's a hard stop in the legislation. And so Congress needs to extend it. And so I think at the end of the year, like, for example, if someone wants to take leave on December 26th and their 80 hours are going to extend into January, I think it's a hard stop, but I suspect the DOL is going to issue some guidance on that for leave that hasn't been completed as of December 31st.
We hope the DOL will, and we hope they'll provide guidance before December 31st.
Yeah, correct. We don't know. I mean, as it is, the leave ends there. What if you're in the middle of leave and it was granted? Does that leave, kind of stop there? All of a sudden, they no longer have the leave when they were granted the leave prior to? I think that will be the clarifying question that, again, DOL, if you're listening, that might be what people would like more information about, Well,
and I think that for example, if they're going to use that 40 hours in the week between Christmas and New Year's, and then they're going to have another 40 after New Year's, is that December 31st stop, and the employer is no longer obligated to pay that portion of the leave after December 31st. So I think that's going to be a question that a lot of people are going to need some help on, especially if the cases continue to rise during the flu season.
Right. Some of the other things I've been talking to businesses about is going back over their cleaning protocols, reminding, like calling in the managers and saying, let's talk about what does this mean? Let's remember, we can't tell anybody the name of someone who has COVID, right? We've talked about that in other podcasts, that, that's medical information and what can you do with that and what can't you do with that? Let's go back to who is your either disaster or pandemic coordinator, whatever you call them. That person needs to be reminding everyone of the policies and procedures in place and the rules. Resend out the FFCRA policy that you put in place. Remind your employees. Things got a little lax over the summer. Now it's back. It's time to tighten that ship. You don't want OSHA coming in, knocking on your door.
Right. And here, if you have COVID cases, there are mandatory reporting requirements that you have to meet. And so you want to make sure that you have complied with that. So now is a really good time, especially as cases are increasing, to pull out your handbook and actually read the policies that you have in place and make sure you're enforcing them. And if you're not sure how to do it, to seek out some help, because, a lot of businesses are struggling with this. People aren't alone. This is new for everybody, including us. We just happen to spend a lot more time thinking about this stuff because we work with it so often than other businesses. But it never helps for a refresher. And we have lots of episodes that we recorded during COVID that can help with all of these issues.
You mean it never hurts, right? It never hurts to get a refresher.
It never hurts. What did I say?
It never helps.
Oh, never hurts.
It never hurts to have a refresher. What I was meaning is seek help if you need it.
Exactly.
Okay. And so, that's all great. I think just before we wrap up here, I think we'll note that, of course, there was some changes that came out of the DOL revising stuff that since many of you may have looked at the FFCRA, so don't forget to check that out. I think we have a podcast on that goes through, the updates on that, the healthcare providers and their exception, as well as make sure that you give leave, even if people can't get you the documentation that you may be requesting for. So,
and also it never hurts to check out the Department of Labor website, the EEOC website, and the CDC website for updated information, as well as your state and local regulations, because a lot of that information has been updated since we even did our podcasts on these subjects earlier this year.
Great point, Camille. Thanks for joining us again on the 3Bs podcast.
Thank you for joining us on today's podcast of 3Bs on the Law. Don't forget to like and subscribe to our podcast. We also welcome any comments. If you'd like to get in touch with us or suggest a future topic, you can email us at 3THREEBsonthelaw@gmail.com. And because we're lawyers, we need to remind you that this podcast is not meant to provide you with legal advice and does not create an attorney-client relationship. Thank you again for joining us, and have a great day.